Hello, everyone, and welcome to a new session with Rights and Responsibilities Awareness Initiative. Today, we are lucky to have Anna Stoll and Christina Martin from Siskinds, the law firm, to talk about a very important topic, which is accident benefits coverage. Thank you, ladies, for being here today with us.
Thank you so much, Hytham, and thank you to the Rights and Responsibilities Awareness Initiative for inviting us to give this presentation. We're very happy to be here. Anna and I both work in the personal injury group at Siskinds, and we're very happy to speak with you all today about statutory accident benefits. And thank you for coming to see our presentation. I apologize in advance for my voice. By the way, I've got a little bit of a cold, but hopefully we can work through that. I'll let Anna take the floor.
Thanks so much, Christina and Hytham. So we'll get started right away. I'm going to share my screen. We've put together a few slides and we're happy to answer any questions that you all have at the end. I'm just going to start sharing my screen now. Christina, does that come off clear? Perfect. So as mentioned, we're going to talk about statutory accident benefits, and essentially this is coverage available through the car insurance system in Ontario. Car insurance coverage is mandatory if you're operating a motor vehicle. So I'll speak primarily about motor vehicles, but if you are operating an ATV or some other type of kind of alternative vehicle, I will call it, you will want to get some guidance from a broker or a lawyer as to whether you require insurance. The reason for this is not just for property damage for vehicles, but what we're here to talk today specifically about is coverage for time missed from work or for treatment and rehabilitation costs as a result of motor vehicle accidents. This supplements as well any medical or disability coverage that you might have privately. So in other words, that coverage would actually have to pay for health and medical benefits required as a result of an accident before the accident benefit scheme and your insurance company would pay. So it is important to talk about in this context, what is a motor vehicle accident? So obviously there are the very clear-cut cases of, two motor vehicles colliding. If someone suffers injury, they can draw upon these benefits from either their own insurer or in certain situations from the other driver's insurer. Again, there's those traditional sorts of circumstances. You may also be eligible to access accident benefits if you are a pedestrian who's hit by another vehicle, and some of the unique situations that we've set out on this slide. Anything essentially involving a vehicle where you've been injured, you will want to seek some legal advice to find out whether you can access accident benefits. There are situations where it is possible and it's not kind of the stereotypical car accident that I've described. So the types of benefits that you can access, I've mentioned a few of them so far, but they would include medical and rehabilitation benefits such as physiotherapy, treatment, massage therapy, counseling, including, social work support or psychotherapy. So those would be some examples of medical and rehabilitation expenses. Attendant care, so this would be care provided by often a personal support worker or a nurse in your home. It can also, under certain circumstances, be care provided by a family member or friend to help you in your recovery. The next type of benefit that you can access would be income replacement benefit. So if you are off of work due to injury from a motor vehicle accident, you can get some income replacement benefits for this, for your missed wages and missed time. In a standard policy, it's usually a maximum of $400 per week. So there's specific circumstances and calculations that need to be run to determine exactly what you would be entitled to. The next would be housekeeping benefits. Those would be usually only available for the most severe injuries that we would call catastrophic injuries, to hire someone to come in and do housekeeping when you're not able to do so as a result of injuries from an accident. Costs of medical assessments, so to understand your injuries better and understand what treatment you may or may not need. And then the last would be if unfortunately there is a death as a result of an accident, there are some benefits available for funeral and death expenses. There are 3 different levels of benefits that an injured person could fall under. The most limited would be those who've sustained what's called a minor injury and would fall under the minor injury guideline. I'll talk a little bit more about what that means in a minute, but essentially folks that fall under that category are limited to $3,500, so $3,500 for treatment as a result of a car accident. They will not be entitled to, anything beyond that. They will not be entitled to an occupational therapy assessment. There's certain things that they aren't able to access in that category. The next category up would be non-catastrophic injuries. It's kind of what I often refer to as the standard track. Folks that fall under this category have access to $65,000, up to $65,000 for treatment and care from a car accident for a duration of 5 years. So under a standard policy. So usually what that would mean is whatever elapses first, so whether it's the 5 years or if the $65,000 runs out, whatever occurs first, those benefits end. And then the highest category is reserved for the most severe injuries. Those are often referred to in our world as catastrophic impairments. They're, as I said, the most serious of injuries. These injuries allow the injured person to access up to $1 million for treatment and care as a result of a car accident. And I should say, when I'm speaking about these monetary amounts, and when I spoke earlier about the amount for income replacement benefit, I'm referring specifically to a standard automobile policy. This is important because some folks have purchased what's called optional benefits when they've purchased their car insurance, and this may allow them for increased entitlements in these areas. So it would be important to discuss this with your broker when you purchase your benefits, and also if you've been involved in an accident, you will want to speak with a lawyer to get full information, to understand fully what your policy allows you to access in your specific circumstances. So I mentioned a moment ago, I described the minor injury guideline in more detail. And again, this is the category of benefits, category of injury, I should say, that allows you up to $3,500 in funding for necessary treatment and care arising out of an accident. The definition of minor injury is included on the slide. But essentially it's focused on items like injuries such as sprains, strains, whiplash. The definition is there, and anything that falls outside of that arguably should fall into the non-catastrophic category or possibly the catastrophic category. As I mentioned earlier, you can't access an in-home assessment in this category. There's no funding for transportation in this category. It is quite limited, and unfortunately, the funding does disappear quite quickly for a lot of injured individuals. There are a number of ways that an injured person could be removed from the minor injury guideline and moved into the non-catastrophic category to allow them to access increased treatment and care. I would say, and Christina will speak about this a little bit more later on in the presentation, but if you have come close to using up this funding, or you have used up this funding, you're still struggling with your symptoms, you're struggling with work, it would be reasonable to reach out to a lawyer to see if you could move out of that category and gain access to increased funding. But some ways that that can be done and that a lawyer can often help with is if you've been diagnosed with chronic pain as a result of your accident, a concussion or a brain injury, mental health injuries such as depression, anxiety, post-traumatic stress disorder. And then another reason too that you can actually be removed from the minor injury guideline is if you had a condition or an illness before your accident that makes it more difficult to recover under the limits of only $3,500. These are just examples again, so you will want to speak with a lawyer if you've used up your funding under the minor injury guideline, or you're close to using up your funding and you are not better, you're still struggling. A call to a lawyer wouldn't hurt to have him or her review your situation and consider whether you could be removed from the minor injury guideline. So I spoke briefly a moment ago about the non-catastrophic, or what we call the standard track. Again, that allows you up to $65,000 for treatment and care available for up to 5 years following an accident. The rules are different, I should say, for minors as far as the longevity of how, their access to funding. They will often have a longer time period to access these benefits. I would say in any circumstance when a child's been injured in a car accident or a motor vehicle accident, it would be prudent and wise to get some legal advice earlier on, sooner rather than later. The non-catastrophic category also, I mentioned that it allows for treatment and care up to $65,000. Attendant care benefits are subject to that same $65,000 limit, and the monthly maximum is $3,000 for treatment and care. And again, this can be provided by a personal support worker, a nurse, or in certain circumstances could actually be provided by family and friends. Again, in this category, there's no funding for transportation, absent really particular circumstances. This can be a major hurdle for folks that don't have a driver's license or are unable to drive as a result of an accident specifically. That would definitely be something that if you're encountering with your insurance company and you're not able to access treatment due to barriers of actually making it into the clinic, you will want to seek some legal advice on that as well. And the highest category that I mentioned a moment ago is catastrophic impairment. And again, this allows for up to $1 million of treatment and care. It's a combined number, so treatment and care together, up to $1 million in a standard policy. And the important thing about this that I would like to point out is someone can be catastrophically impaired as a result of physical injuries, brain injury, so more cognitive impairments, intellectual impairments as a result of brain injury, headaches. There are many symptoms that come with concussion and brain injury, but also psychological impairments. So a combination of those, or on their own can amount in certain circumstances to a catastrophic impairment. If you are at all wondering whether you've sustained a catastrophic impairment as a result of an accident, again, you're sensing a theme here, but this would be another time that you would want to consult with a lawyer. Again, Christina will speak about this in more detail, but I should say that most personal injury lawyers will speak with you without charging any money to speak with you. They'd be happy to sit down with you or chat with you on the phone about your situation and give you advice. So I will turn it over to Christina. Thank you so much.
Thank you, Anna. What I'd like to do next is take you through some of the forms that you may encounter when making a claim for statutory accident benefits. I always tell my clients that the accident benefits regime is very much a square peg in a square hole regime. There are specific forms and they have to be filled out in specific ways. And those forms can be mystifying for people. So if you bear with me here, I'm going to share my screen and share with you some of the forms that you can expect to encounter if you've been involved in an accident and need to make a claim for statutory accident benefits. Now, hopefully you can see that. Anna, can you see that? Okay, excellent. Now, we touched on the fact that there are different circumstances that may entitle a person to make a claim for accident benefits. In many circumstances, you may be driving your own vehicle and have your own insurance policy, in which case your own insurance company is going to provide you with an accident benefits application package, which is going to contain a number of different documents for you or your providers to fill out. But there are other circumstances. You may be a pedestrian and need to claim against the vehicle insurance of the vehicle that hit you. And in certain circumstances, neither the injured person nor the vehicle involved has insurance. And in those somewhat rare circumstances, there's also an avenue to claim against the Motor Vehicle Claim Fund, which is essentially a government fund that allows people to access accident benefits. But the bottom line is, in order to get your accident benefits claim started and begin accessing some of those benefits that Anna has outlined for you, you will need to fill out an application. And the first of those forms is called the application, or the OCF-1, and it's going to have lots of questions pertaining to whether you own the vehicle, whether you were driving somebody else's vehicle, are you listed on the policy or not? Were you a passenger in somebody else's vehicle? Were you a pedestrian? Was it an uninsured automobile that was involved in the accident? And it takes you through those different scenarios, and it kind of points you exactly where you need to go in the application, depending on what scenario applies in your case. The application is going to ask for general information. It's going to ask about your representative. It's going to ask about accident details. And it's important that you provide accurate information and be mindful about the information that you're providing in these forms, as they will get circulated between healthcare providers, but they also will be producible if you ultimately have a lawsuit or a tort claim. So you do want to give thought to preparing these forms, and it's often prudent to seek legal advice before submitting these forms to ensure that they're being completed accurately and appropriately. It will ask about what medical information, what medical treatment you've received since the collision, details about your health providers, and then details about your insurance, and also about other insurance that you may have access to. And Anna touched on the fact that if you have extended healthcare benefits through work, for instance, or through a spouse's policy, those policies are first payors. And so you have to include that information in the application. The application goes on to ask about work, school, earnings, whether you're a caregiver, and many other details, which allows the insurance company to understand what benefits you are looking to access and which you may be entitled or not entitled to access. Okay, the next form is a disability certificate. Now, the disability certificate needs to be provided and completed by your healthcare provider. That could be a family doctor, could be a chiropractor. It actually delineates in the form what different types of healthcare providers can complete the form, but psychologist, nurse practitioner, etc. When you approach your practitioner, your healthcare provider, and ask them to complete this form on your behalf, it's prudent to ask them to ensure they're thorough when outlining the diagnoses and your symptoms. It's important to talk to your provider and ask them to be realistic about your efforts or abilities to resume your activities of daily living, including work. Sometimes providers may underestimate the amount of time it takes for a person to be able to resume those activities, and if that happens, it can present a hurdle if it takes longer than was originally anticipated. And so an accurate reflection, a thoughtful reflection of how long it may take to be able to get back to work or other activities is important. Anna touched on the fact that in certain circumstances, a pre-existing medical condition may be sufficient to entitle a person who was otherwise going to be placed in the minor injury category to be placed in that middle track that she was talking about and have access to the $65,000. And so it's important that your provider who is completing this certificate is clear about any pre-existing conditions that may impact your ability to recover if you were subject, excuse me, to the $3,500 cap. And again, this form has to be signed by your healthcare provider and also by you. All right, the next form is a treatment and assessment plan. So again, accident benefits regime requires individuals to use specific forms in order to access treatment. And one of those forms is an OCF-18 or a treatment plan. And this form will be completed by your providers. And it will have details about the provider and also about what exactly they're looking for the insurance company to fund for you in regards to treatment. And why? What is the goal of the treatment? How are the injuries impacting your activities of daily living, work, etc.? And the form has to be signed both by the treatment provider who's submitting the form. So for instance, your physiotherapist, your psychologist, your occupational therapist, etc. And it also needs to be signed by you. And the form then needs to be submitted through a specific portal, for lack of a better word. It's called HCI. Many providers have access to it, but some don't. And unfortunately, these forms do have to be submitted through the particular avenues in order for the insurer, in most cases, to consider it. Importantly, treatment that is proposed that you wish to have funded by your insurance company or the insurance company that's responding to your claim must first be submitted using one of these forms. If you, for instance, go off and get some physiotherapy without completing, without having submitted an OCF-18 and later ask your insurance company for reimbursement, they may be within their rights to deny that request because you didn't first submit the request on the specific form that is required. And unfortunately, we have seen circumstances of folks who get caught unawares in that regard. So submitting a treatment plan is important. Your insurance company can either then, at that point in time, approve the plan in its entirety, partially approve the plan. So for instance, let's say your provider thought you needed 20 physiotherapy sessions and your insurance company said, we don't think you need 20, but we'll approve 15. Okay, so they can partially approve the plan, or perhaps they don't like the hourly rate of the provider and they approve the treatment, but only a different hourly rate. And there can be hurdles there in terms of accessing treatment because the prescribed rates under these schedules are not in line with market rates sometimes, but that's a story for another day. Or your insurer can deny the plan altogether. So your insurer may say, we don't think you need physiotherapy at all, and we're not paying for it. And that's a conundrum for folks, because it certainly limits their ability to access treatment that they may well need to recover from their injuries. And that's certainly a situation where you may want to ask for the advice of a lawyer to help you through that, barrier. An insurance company has 10 days to respond to your treatment plan by either approving it or denying it or partially approving it. If they fail to respond, and this doesn't happen very often, but if they fail to respond within that prescribed time frame, the treatment can be deemed approved. So there's certain portions of the regulations which, in essence, deem the insurer to have approved the treatment if they've failed to respond to the treatment plan in a timely fashion. Okay, Anna, if you want to pick back up at slide 14, that would be helpful. Bear with us here. Thank you. All right. So another thing that an insurance company can do is deny treatment or request for funding, including, for instance, for income replacement benefits or non-earner benefits or attendant care benefits, those different kinds of benefits that Anna went over with you, pending the outcome of an insurer examination. And you may wonder, what's an insurance examination? Well, the regulations permit that in certain circumstances, the insurance company has a right for you to undergo one or more assessments with doctors or other healthcare providers of their choosing to determine your entitlement to benefits that you are claiming, or for instance, to determine whether the minor injury guideline does or does not apply to you. That's quite common. In fact, we regularly see insurance companies stick people in the minor injury category who have no business being in the minor injury category and who really ought to be at least in that middle category that Anna is talking about. And I've even seen a circumstance where one of my clients was stuck in the minor injury category and ended up being catastrophically impaired. So insurers get it wrong all the time. And often they ask for insurer examinations to be conducted. And there certainly are circumstances where you will have to participate in those. Most of them are conducted in person. Sometimes they're conducted by way of paper review. But it's important to know that not all requests for insurance examinations are reasonable. And it is a good idea to seek some advice before you participate in any. It's not uncommon for insurance companies to request too many assessments. We see that regularly. Sometimes insurer examinations are requested with a specialty or discipline that really doesn't make sense in the circumstances, with reference to either the type of benefit that's being claimed or the injuries that are involved, and a different type of medical practitioner would be more appropriate in those circumstances. So it's a good idea to seek advice of a personal injury lawyer before you participate in an insurance examination. It is also important, though, to highlight that if you do fail to comply with a reasonable request, an appropriate request to participate in an insurer examination, that can impact your entitlement to benefits. Your insurance company could place you in what's called non-compliance, and in essence, suspend benefits, whether that be an income replacement benefit or a non-earner benefit or the medical benefit in question, so physiotherapy treatment or psychology treatment, whatever, pending your compliance. And they do have the right to do that in certain circumstances, so it's important to be aware. All right, we can go to the next screen then. All right, so Anna touched on this throughout her presentation, but you may wonder, well, when do I need to consult with a lawyer? And anytime that you've been involved in an accident, it would be a good idea to seek legal advice early on. Early intervention often leads to more optimal results, but there are some flags or triggers which may really prompt you to think about seeking some advice. That would include if you've not returned to work or normal activities of daily living, if you've not received adequate treatment or care, or if your insurance company is denying otherwise necessary medical care that your providers think is necessary. Anytime your insurance company is requesting that you participate in an insurer examination, Anytime your injury may be deemed catastrophic, orthopedic injuries, brain injuries, significant mental health claims, and as Anna touched on, claims involving children, because those certainly can evolve. And many people wonder, certainly those who have been involved in accidents and who may be off of work and have limited income, if they can afford a lawyer. And Anna touched on this, but most personal injury lawyers do not charge for consultation. And certainly at Siskinds, we do not charge for the initial consultation. Anna, myself, or any of the lawyers in our group would be happy to speak with you about what your rights may or may not be if you've been involved in an accident, or maybe you're wondering if you were involved in an accident as defined by the statute. And we would be happy to speak with you, as would our colleagues in that regard. Most personal injury lawyers work on a contingency fee retainer basis. So rather than being charged on an hourly rate, a percentage is taken at the end of the file if a settlement or is achieved or damages are awarded. And there are certain avenues to funding the cost of litigation without the payment from the client, and also to get access to treatment pending working through the dispute resolution process if you're faced with a denial by your insurance company. And finally, how can we help? How can we help at Siskinds? And we'd be happy to speak with you if you're involved in an accident. In short, we're a large firm with expertise and resources. We have partners with many, many years of experience, senior associates like Anna and I, and then a whole team that will be able to assist and provide guidance. We're in contact with a large network of rehab and medical specialists, so we can make referrals for you or provide recommendations of folks that may be able to provide you with some care. Our team will liaise with your care and treatment team in order to help you gain access to the benefits that you may well be entitled to and the care that you need. We can facilitate getting funding for treatment or other benefits such as income replacement benefits or tenant care or non-earner benefits. We've touched on a few times during this presentation, but early involvement can often optimize the results. I have seen personally circumstances where folks have come quite a bit down the road, and they've already undergone numerous and sometimes unreasonable insurer examinations and other things. And if we're involved earlier on, we can facilitate access to benefits and sort of guide you through the process and help you understand which assessments may or may not be reasonable. And we on a day-to-day basis help our clients through difficult and confusing process. It's really our bread and butter, and we advocate for those who can't.
Of course you do, my friend.
All right, well that takes us to the end of our presentation, but we would be happy to address any questions that may have come up.
Oh yes, we do have some good questions actually. So let's start by the first one. As you know, sometimes some of the damages or the harms might take a little bit of time after the accident, so they might not be raised until a certain period of time. How much time frame any person who is being injured by an accident has in order to submit an application? Or on the other side of the coin, could that application that already submitted amended if anything developed by as a result of this accident?
That's a great question. So rule of thumb is that you have 2 years to submit an application for accident benefits. There are some circumstances where that could be extended in certain circumstances, but the rule of thumb would be within 2 years. but best practice would be to submit it as soon as you know you have any injuries from an accident. And it's not uncommon that an individual's injuries and impairments evolve. Some folks get better over time, but some folks worsen. And as you say, new impairments come to light or manifest themselves. Sometimes psychological impairments take some time to manifest as a person is struggling with chronic pain or a brain injury and changes to their function. Mental health conditions can flow and they may not be immediately manifest and only later arise. I think the important thing to understand is that accident benefits are payable for injuries that are directly result of an accident. And so you do need medical evidence that links what you're dealing with, what your injuries are, what your impairments and your symptoms are, and the treatment that's being recommended to the accident in question, as opposed to some other either intervening event or pre-existing event, although certainly pre-existing problems can be made worse by an accident. And so clear and thorough and accurate reporting regularly to your treatment providers and ensuring that those problems are documented along the way, including any worsening or newly arising symptoms or impairments, is paramount.
Thank you very much for this. So another question is, would the accident benefit claim prevent the person from filing a tort lawsuit afterwards as a result of the accident?
I'm happy to answer this, Christina. So no, not at all. You can certainly pursue both. Usually at the outset, because the primary concern is often getting the treatment that you need and any income replacement benefits for time away from work, that often will happen first. And if you're not getting better, you haven't returned to work and you're still struggling after a certain period of time, you'll want to seek that legal advice that we were talking about earlier. And oftentimes in a situation like that, a lawyer may recommend that you pursue a tort or civil claim as well. It's the same thing, just two different words for the same thing. But most of our clients that have been involved in an accident, or virtually all of our clients that have been involved in some kind of motor vehicle accident, we assist them with both pieces. So a tort claim and an accident benefits claim. So, some folks, if they were at fault for their accident, they may only have access to the accident benefits regime. Anyone can access that, even if the accident was their fault. But for folks where, the accident either was not their fault at all or was not entirely their fault, they will have access to both streams. And oftentimes it's beneficial to access both the accident benefits regime, but also pursue a civil or tort claim.
Thank you very much for that. And this is another interesting question. What if I made a mistake when I was filling my forms? How could that be solved?
It's a great question. That can be solved in a number of different ways, but often a simple letter to the adjuster will suffice. In certain circumstances, they may want you to complete a new application or substitute the page with the correct information or the like, but that should not present a barrier.
There is another question, but I'm gonna ask it anyway. In car accident, there is an amount of deduction with every insurance policy. Is the same rules apply for personal injury?
Yeah, so that's a very good question. As far as the accident benefits regime, regardless of, if you have a minor injury, and we spoke about the minor injury guideline, you should be able to access the treatment that you need under that category or an increased category if appropriate. There are deductibles and thresholds and a lot of kind of complex nuances that apply to a civil or tort claim. So you will want to speak with a lawyer about how those may apply to your situation. But as far as, your own insurance and injury coverage through accident benefits, deductibles shouldn't be a barrier per se, in the way that they are for vehicle damage. Christina, I don't know if you have anything to add, but it's a complex question.
No, the bottom line is that the deductibles, the deductible issue doesn't apply in the accident benefits portion of your claim, but if you have a tort claim or a lawsuit, there certainly will be things you need to know and discuss with a lawyer about thresholds and deductibles and how those may or may not serve to decrease the amount that you're ultimately entitled to.
Thank you so much. So we've got another two questions, actually. One, what if I get in disagreement with my insurance company, what is the party, the governmental body, the court would be entitled to solve such as dispute between us?
That's a great question, and we didn't touch on it in any detail in our presentation, but if your insurance company denies a request for treatment or a request for a benefit, like an income replacement benefit, you have 2 years from the date of that denial to bring an application, and there's certain forms again that you have to use, but to bring an application with the License Appeal Tribunal, and that's the governmental body, the tribunal, which has been tasked with dealing with accident benefits disputes. And the tribunal deals with essentially all accident benefits disputes, starting with, first and foremost, whether you're entitled to bring an accident benefits claim at all, right? Was your incident an accident, an automobile accident or not, which Anna touched on, through to, is my injury a minor injury or not? Is my injury a catastrophic impairment or not? Am I entitled to this or that treatment? Am I entitled to this or that weekly benefit, whether it's an income replacement or a non-earner, and everything in between. So the License Appeal Tribunal has jurisdiction to deal with those disputes. And then there is an appeal process, which can ultimately find its way to the court process, the Superior Court, the Divisional Court actually, process, and beyond in certain circumstances. But by and large, it is the License Appeal Tribunal that's dealing with those kinds of disputes with your insurance company.
Thank you very much. And last but not least, we've got the final question. Could you please enlighten us a little bit more about the contingency plans, please?
Sure. So the system has actually been somewhat updated in recent years by the Law Society. So you can actually get a lot more information just by looking at the websites of anyone who's practicing law under a contingency type arrangement. And most personal injury lawyers practice in this way, simply because I think Christina mentioned this, but a lot of our clients, because they're injured, they are either not earning as much of an income or they are not able to earn an income. So we wouldn't be very effective with our clients if we were regularly billing an hourly rate. So that being said, oftentimes when we assist clients with both the civil and the civil or tort claim and accident benefits, we charge a percentage rate. Now, the Law Society actually requires lawyers doing this to publish the maximum rate that they will charge on their websites. And the agreement that they will review with you in detail and answer any questions you have will have that rate set out in it. The agreement that you sign to the contingency fee agreement will also explain this in detail. It will outline examples as to how it works. But you should certainly not be afraid to ask any lawyers that you're consulting with to explain things in a different way or provide other examples to illustrate how the fee works. The way that I often explain it to clients at the outset would be it's kind of like, you know, those billboards you might see driving through the States. In simple terms, it's we don't get paid unless you get paid. That's the most simple way to explain it. So in other words, if we're able to successfully negotiate a settlement for you or a judgment is rendered by a court, we collect a percentage at the end of the day of what we're able to recover for you. And again, based on the information provided required to be provided on a lawyer's website or a law firm's website, as well as the contingency fee agreement that they'll have you sign. There should never be any mystery as to what that percentage will be. The other thing that I think is important to mention too is if and when you reach a point in your case where you and your lawyer have decided it's appropriate to maybe consider settlement and negotiating and coming up with a resolution for your legal matter, you should not be afraid, and the lawyer should anyway go through with you what that breakdown looks like, so that before you agree to anything or before you make any offers through your lawyer to the other side, it's very, very clear to you what that means, to you. Again, so there are no surprises at the end of the day.
Thank you very much. Actually, we've got another question from John on LinkedIn. If you could make one change to the SABS legislation to improve it for your clients, what would that be?
Great question. So many changes. But I think what comes to mind for me is to revert back to the old limits that used to be available for catastrophically impaired folks, save and except for those who have purchased optional benefits. So it used to be the case up until about 2016, I think, that if you were deemed catastrophically impaired, you would have $1 million for medical and rehabilitation and $1 million for attendant care. And if you think of those folks who are, who are the worst injured in an accident, those folks often needed that care, and even that level of care wasn't enough for them. Unfortunately, the system changed and it merged those two types of benefits under one policy limit of 1 million. And for folks who are grievously injured in an accident, it's very common that $1 million limit does not take them through their whole life. And the kinds of needs that those folks may have. And so that's probably what comes to mind for me. What about you, Anna?
That would definitely be one of the things that would come to mind for me. Another area that really, really grinds my gears are the rules pertaining to attendant care. So specifically, there's a lot of problems with the attendant care system. And so again, that's care and support often in someone's home with tasks of daily living. So again, this would apply to the more injured people on the spectrum in most cases. There's lots of rules, but the most concerning that comes to mind offhand is that often attendant care providers, the rates that are set out for them, the hourly rates, some of them actually dip below the minimum wage. And the other problem too is that, there's very, very strict restrictions on who can actually be paid to provide care. The problematic situations I see often in my practice would be, and I'm sure Christina sees these regularly too, where, a family member, the injured person prefers that a family member provide the care, and there's just such specific rules as to when that's required, to the point that often it's not possible. And in order to access care, you have to go through a provider, which can be great, but sometimes people are also not comfortable with that. So anyway, lots of areas for improvement, lots of ways the system could be more accessible, and help people get back to their activities of daily living and help people return to work that just unfortunately are not there.
So ladies, we do have another question from Jim on LinkedIn. So can you speak to the differences between the SAPs and the tort settlements when it came to settlement, specifically the insurance ability to force a structured settlement for SAPs versus torts?
That's a very big question.
Yeah, that question has some complexities. So Anna touched on the fact that the tort claim and the accident benefits claim, you can think of those as parallel claims that run together. There's some overlapping, in other words, and we won't get into the nuances of it here, but the tort claim or the civil lawsuit can claim some credit for the amounts that you might get on the accident benefit side of things. But those run parallel. They may settle at the same time. They may settle at different times. With regards to structured settlements, it's not typical that an insurer can force a structured settlement because they can't force you to settle at all. However, there are circumstances where a structured settlement is certainly advantageous and the best option for the individual in question. And there are other circumstances where a structured settlement doesn't make sense for the individual in question. And those differences can be very nuanced and probably beyond the scope of what we can talk about today. But the bottom line is, A, it's not typical for an insurance company to be able to force a settlement or any particular type of settlement. But B, there certainly are circumstances where a structure will be advantageous to the individual and other circumstances where it will not be, and that's very, very fact specific.
And this is maybe actually answered the other question from Jim, that can you express your general views for structure versus a lump sum settlement?
Yeah, it's very, very fact specific. There are a number of reasons and circumstances where a structure may be most advantageous for an individual, but other circumstances where a structure may not make sense for a particular individual, and so it really depends on the circumstances and the facts. A lot of times structured settlements will be considered in circumstances where the individual is a person under disability and can't control their own finances, for instance. That's one area where it comes up a lot, but it's very fact specific.
Well,
your lawyer should discuss all of that with you before you agree to a settlement. You actually have to not only agree that you're settling with your insurer or with the, with defense counsel in a tort claim, but you'd have to actually agree as to whether it's being structured and possibly some of the terms of the structure before it's all concluded. So your lawyer should definitely provide you advice on that, including, giving you the opportunity to meet with an expert in structures, because we meet the experts in the law and certain factors as to whether a structure would be worth considering, but there are experts on structures themselves that your lawyer could connect you with. But yeah, as Christina said, it's very, very complicated, and it will really depend on the personal circumstances of the injured person and their families and what their goals are.
Case by case basis.
Yeah.
Okay, so well, we've got another question actually, but I think we've answered this. Does the accident benefit settlement affects the tort settlement? And I think your answer to this was no.
Well, not exactly. So the previous question was a little different insofar as starting an accident benefits claim does not preclude you from starting a tort claim. And in fact, it's quite common for people to have both of those claims going at the same time. They're parallel claims. There are some overlap. Does an accident benefits settlement affect the tort settlement or the value of the tort claim? The answer is maybe. Sometimes it does. And the reason for that, and there are nuances which we can't delve into today, but the way that the civil tort structure for damages is structured is that the defendant does get some credit in most circumstances for accident benefits received. So for instance, there may be an offset for certain medical benefits that have been received or for income replacement benefits that have been received. And so the amount of the accident benefit settlement can inform the tort settlement in certain circumstances or heads of damage in the tort context.
Thank you very much. I'm taking a look to our social media platforms in order to find if there is any other questions so far, and taking into consideration that nothing posted new. So I will take this opportunity to thank you both, Christina and Anna, for this valuable and fruitful information. You've enlightened us about a lot of procedures, facts, and circumstances that so many people, especially newcomers, that may not be aware of. And actually, could be You know, this situation could happen to anyone. So this is very, very important to know. And thank you very much for being willing to answer any further questions later on by anyone who has some kind of a case he would like to talk about. This is highly, highly appreciated, ladies.
Well, thank you. Thank you for everyone who participated and watched. And thank you, Haitham, for inviting us to speak. It's been our pleasure.
By all means, you are more than welcome, and it was an honor to have you. And this session will be interpreted into Arabic, Spanish, and Mandarin, and will be restreamed also on our social media platforms and those languages. So thank you everyone for today, and we are looking forward to see you at another session with Rights and Responsibilities Awareness Initiative. Stay well, stay safe, and have a wonderful rest of your day, everyone. Bye-bye.
Thank you. Bye-bye.
Thank you.